4907, is that correct?
That's correct, Mr. Chairman.
Thanks.
Good afternoon, Mr. Chairman, Madam Vice Chair, members of the committee. My name is Jack Walker. I'm the Vice President for Legislative Affairs for the Texas Trial Lawyers Association, testifying against House Bill 4907. I want to thank, first of all, Chairman Guillen for meeting with us to discuss our concerns with this bill. 4907 seeks to abolish both public and private nuisance claims as they relate to carbon capture. It's a little bit like Groundhog Day. This is the third time I've been in front of y'all this session talking to you about nuisance, second time about carbon capture. I don't plan on repeating anything, except I would repeat this. I have met now most of the members of the committee, and I know that this committee is made up of very, very good lawyers. Nuisance is a common law right. This committee needs to be suspect of any law that seeks to abolish these rights and claims under common law. These rights have been in our jurisprudence for centuries for a reason. They are needed, and once they're gone, they're not coming back. This is an untested industry. The process of capturing and storing CO2 is relatively new, and why are we going to rush to abolish well-established common law rights to provide protections to these businesses before we know exactly what we're dealing with? The CO2 we're talking about is not just simply one atom of carbon, two atoms of oxygen. As I've talked about before, it's going to include substances like benzene, toluene, and xylene, and every other dangerous chemical in the carbon chain of petrochemical production. So I want to draw your attention to the definition of captured or stored CO2, because it's very troubling. First of all, it says that captured or stored CO2, not only not a nuisance, it's not a pollutant. Now, benzene, the EPA defines benzene as a hazardous air pollutant that may cause cancer as well as damage reproductive, immune, and neurological systems. Toluene has been defined as a major indoor pollutant by the NIH, and xylene, the CDC has warned that it can cause systemic toxicity by ingestion or inhalation. These are all pollutants in every sense of the word, and this bill as written would define them as not being pollutants, which is contrary to law. Nothing we have faced this session has tried to abolish private nuisances. What I've talked to you about this far is public nuisance, that is the government's right to bring nuisance claims. This actually abolishes the right for private landowners to bring a nuisance claim in order to address problems with carbon capture. And so what I would say is, if you take a situation where, let's say, captured carbon pollutes a water table, you're not going to get CO2 and water in Perrier and Topo Chico. You're going to get polluted water, and you're taking away the right of the victim, the landowners, and the government, of public nuisance, to address that harm with nuisance. And the main thing that nuisance does is it allows for abatement of the problem and the issue and damages for future harm. We would ask you to not allow this bill through and to vote against it. And I'm happy to take any questions, Mr. Chairman.
Thank you, Jack. Members, any questions? Okay, thanks for your testimony. Thanks to each of you.
Thank you.